Let's schedule another disc. I'll have all this stuff ready.
Tribalism, you're on it pretty good.
So I was watching this over again. Someone came into my comment section and started asking me about the magical stout pro se litigators. And if you're wondering, if anyone is wondering why I'm just laughing my ass off this entire video, it's because there was a premise that we were going to debate, that Mark Stout and I were going to debate. And his premise was something like all city halls are limited public forums or something like that. And then he changed it in the pre-show. In the pre-show, he changed it to he just wanted to talk about this specific case, Sheets versus the city of Punta Gorda. I'm just mumbling in here while people filter in. So this is Sheets versus the city of Punta Gorda, and let's see. This is the operative language that Mark couldn't seem to understand. It's here in this case, i.e., for the purpose of this decision, the parties agree that City Hall is a limited public forum. See also, as in it's not controlling, but it helps to back up the position of the parties that the City Hall is a limited public forum, where there is a Punta Gorda code section that says City Hall is a limited public forum. Now, I can't argue this case. This case exists. I made a video on this case long before I debated Stout. Let's see. Let's go to my channel, your channel, and I could do this little one. Punta. Got to get that. So you can see that 3 years ago, I made not one, but 2 videos on Sheets versus the city of Punta Gorda. I spent about an hour talking about Sheets versus the city of Punta Gorda about 3 years ago. So, I mean, I am aware of the case. I have dissected the case. I didn't come up with any different conclusion than Mark did about the holding of that case as applied to that case. And in fact, Mark might have just watched my videos and been regurgitating what I said. Now, the weird thing about this video is that from this one case, and then he brings up some other cases. He doesn't like make any real good arguments on anything, but he wants to extrapolate Sheets versus city of Punta Gorda to every other city hall in the U.S. Every other city hall in the U.S. is a limited public forum, according to Mark, because of Sheets versus the city of Punta Gorda. And his big argument, is this case law? Is this case law? Yeah, it's case law. That doesn't mean it's controlling. That doesn't mean that any other district court out there anywhere would have to find as a matter of law that a city hall is a limited public forum. Here, the court didn't decide that the city hall was a limited public forum. It just said, basically for the purposes of this, the parties have agreed it's a limited public forum. No other district court has to find like an airport is a non-public forum. How do you know it's a non-public forum? Because the Supreme Court said an airport is a non-public forum. A post office is a non-public forum. How do you know that? Well, because the Supreme Court said a post office is a non-public forum. The Kokinda and Lee versus the International Society for Christian Consciousness are the 2 citations there. A jail, non-public forum. How do you know that? Because Adderley versus Florida. Military base, non-public forum. How do you know that? Because of Spock versus Greer. City Hall doesn't have that. City Hall does not have that case law. And so in order to determine what kind of a forum a specific city hall is, or even a section of a specific city hall. You have to look at the facts of that particular city hall. What's the use that particular area has been used for? Has it been held out as a free speech zone, as a public forum? I mean, you have to look at the specifics of the case. And then when I tried to talk to Mark about that, like, hey, well, what about this? What if every time like a whole city full of Japanese or a bus full of Japanese tourists comes into City Hall and starts taking pictures, and they don't do anything about that? And he's like, oh, I can't speculate on that. I have to stick with the facts of Punta Gorda. I can extrapolate the facts of Punta Gorda out to every city hall ever, but if you give me specific facts about what's going on in a specific city hall, then I can't speculate on it. So it was a joke. The whole debate, in air quotes, was a joke, which is why I was laughing the entire time. I mean, I'm sure Mark thought that he was scoring points, and that's fine. And, you know, I'm sure that a lot of people didn't understand why it was so fucking hilarious. But the bait and switch at the beginning, I'm going to debate you about X. And then as soon as we get there, he's like, I don't want to debate you about X. I want to talk to you about Y. His whole point is that this case exists. And then what, you know? And then what? Like, what am I supposed to do with that? And every time I try to get him into a thought exercise to extrapolate it out to actual fact patterns, he can't do anything. Mostly my penis. Is there a problem with that? So anyway, that's not what you guys came here for. It wasn't for my brilliant performance against Mark Stout, where all I could do was just laugh at how stupid it was. Today we are going to talk about Decastro. So we have plaintiff's motion to reconsider. I don't think I've talked about this one. I have read this one. Did I talk about it? I think I did. So he's doing FRCP 59E. I think he's supposed to be going under 60, but that's fine. Yeah, I think I did talk about this one. All right, so move on to this one. This is plaintiff's motion to correct. Pursuant to FRCP Rule 60A. Let's just look at FRCP Rule 60A. Corrections based on clerical mistakes, oversights, and omissions. So what this is normally for is like if there's an order made, and a clerical mistake doesn't mean like a mistake by the clerk. It means a clerical error, like a scrivener's error, like where the judgment is supposed to be for 1.5 million, and instead you add in an extra set of zeros and it's 1.5 billion. Well, the court didn't actually order that. That's just a clerical mistake. That's just a scrivener's error. So that's what these are for. So it's just a, you know, it's basically just like typos and things like that. That's what this is for. So we'll go ahead and continue on with that. He respectfully moves this court to correct an error in its clerk's judgment entered August 3rd, 2023. So let's look at the clerk's judgment. I don't have that up, so I need to grab it. And the clerk's judgment was August 3rd. Oh, I'll do this too. That up. I'm going to go back one, and we're going to download this one. I'm going to share this tab. All right, so judgment in a civil case. Decision by the court. The action came to a trial or hearing before the court. The issues have been tried or heard, and a decision has been rendered. The court granted. This is not a clerk's judgment. This is not a clerk's judgment. The court granted the defendant's motion to dismiss and the city's motion for judgment on the pleadings and dismissed his complaint. I guess technically in the order it didn't say judgment for the defendants. I guess it just said dismissed. I guess that's how they're doing it. All right. So what is his problem with this? I don't know what his problem with this is. Here is the judge's order. I know I could just skip ahead and actually find out what's the problem with it is. But let's find out what the problem is. So he dismissed the complaint. I don't know. Let's find out. Let's find out what the problem is. In support of the motion, there's a memorandum of points and authorities, yada, yada. So he filed a First Amendment complaint demanding a jury trial. In September, defense filed pretrial dispositive motions, ECF 21 and 23. But let's look at those. So ECF 21. Download, save, and 23. Download, save. All right. So this is 23. There's their motion, and this is 21. There's their motion. Okay. I don't see a problem yet. On January 13th, after being granted leave to extend his response deadline, he filed an opposition, ECF 32. Well, let's look at that. Let's look at 32. Let's look at 32. Download. And we'll open that. And okay. I don't see a problem yet. Wait, we're on this one. All right. On August 3rd, the court entered an order. Yeah, okay. On August 3rd, the clerk entered clerk's judgment. Yeah. Indicating this action came to trial or hearing before the court. The issues have been tried or heard, and the decision has been rendered. That is incorrect. There was no trial here. There's no hearing on the matter. There's no hearing on the matter? Am I stupid? Don't answer that. So this appears that he is, the court has reviewed the orders, or the motions, and has rendered a decision on the pleadings themselves, or on the moving papers themselves. Why is he saying there's no hearing? Is he saying there's been no oral argument? Why does there have to be an oral argument? This court has the authority to make corrections. Pursuant to FRCP 60A, the court may correct a clerical mistake or a mistake arising from an oversight or omission, whether one is found, yada, yada. The judgment should say something more similar to decision by the court. The action was decided by the court without trial or hearing. By trial without oral argument, maybe, but there was a hearing. I mean, that's what the paperwork was for. Question about RFA number 1, question 20. That's a great question. I'll have to get back to you on that, sir. Let's see. So my first question is, why does this matter? Why does it change anything? And number two, there was a hearing on it. It was just the hearing was done on the paperwork submitted. They have duty to correct it. But why does it matter? FRCP 78. 78. There's FRCP 78. By rule or order, the court may submit or provide for submitting and determining motions on briefs without oral hearings. It's an oral hearing, but they're not saying it was an oral hearing. So let's see. Local Rules, Southern District of Ohio. And these are the most recent ones. And without oral hearings. Procedure to obtain a hearing or oral argument, evidentiary hearings. An evidentiary hearing is where you actually bring witnesses, introduce things into evidence, the whole shebang. It's not necessarily the end trial, even though the end trial would be an evidentiary hearing of sorts, but an evidentiary hearing is where you actually introduce evidence, not attach an affidavit to your motion or attach a printout of the thing to your motion, but actually all the rules of evidence kind of evidentiary hearing. Movement shall. So I don't believe that a motion for summary judgment or a motion for 12b6 motion to dismiss are evidentiary hearings, so I don't think that applies. If oral argument is seen to be essential to the fair resolution of the case because of its public importance or the complexity of the factual legal issues, counsel or pro se party may apply to the court for oral argument. This may be done by including the phrase oral argument requested or its equivalent on the caption of a motion or on a memorandum. So let's look at, this is 23. Let's just do a search. Oral. No oral argument. This is just make sure that it's word searchable. So it is word searchable, and there's no mention of oral argument. This is plaintiff's response. Just make sure it's word searchable. It is word searchable. So we're searching for oral. No mention of oral. Oh, you didn't see that. That was this one. So Chile didn't ask for it. So let's do, this one is document 21. No oral. Let's just make sure it is word searchable. It is word searchable. Okay, so no one asked for it. So, all right, so we're going to go back to this one. And then they actually have to lay forth the grounds, succinctly explained. Well, that precludes Chile from being able to do it. If the court determines argument or a conference would be helpful, the court will notify all parties. Let's see if there was a notification. Share this tab instead. We're going to go back. We're going to look for a notification on, let's just look for oral. There were no oral arguments, but that was it. That's the only, there is no oral argument ordered. So, oopsie fucking doodle. So anyway, I don't think that this is going to go anywhere. And even if it did go somewhere, I don't know why it matters. So that's a waste of fucking time. Thanks for that 10 minutes of my life I'll never get back. And then we have plaintiff's second motion to consider. So the first motion to consider was on to reconsider the order of August 3rd. That's the one granting the motion for judgment on the pleadings. Oh, this one is granting defense motion to dismiss for failure to state a claim. All right, so this is the 12b6, which he didn't address in the first one. So let's I have no idea, Kevin. I don't subscribe to his channel either, nor do I see his stuff because I'm not a retard and I don't look to ex-cons who are drug-addled to get my understanding of the law. All right, so in support of the motion, yada yada. Introduction: he filed the First Amendment complaint in this action, including a jury trial demand containing claims for violations of his civil rights under the First, Fourth, and 14th Amendments of the United States Constitution against Wagner, Spoljarek, Blankenship, McKnight, and Robert Fauch in their individual capacities and in their official capacities under a Manel claim. So hold on a second. Let's we're gonna have to look at the First Amendment complaint. It's a really nice day today. It's overcast with a slight breeze. Apparently it's going to rain tomorrow. Apparently it's going to rain tomorrow. I'm looking for, I don't know why I didn't just submit a complaint. Here we go. All right. Well, he didn't name the city of Ironton or the county. He didn't name the city or the county up here as defendants, so that's interesting. In here, they do talk about the city of Ironton in the party section, but it doesn't state in here that the city of Ironton is a defendant or that the county is a defendant. So that's interesting. All right. What are we going to do here? The First Amendment, yada, yada. Fourth Amendment claims, yada, yada. Besides facts alleged in the complaint, he included an exhibit which contained video of the incidents. Plural. Incidents, plural. I'm sure it was the raw footage, unedited. You don't get nothing like that for free, Vlad. Oh, by the way, donate to Mission 22. Veterans, they come home. They don't get much love and support from the federal government. They come back broken. There's a high incidence of suicide, drug abuse, homelessness. Donate to Mission 22. It's a different hat, by the way. It's a nice hat. You could buy these hats on their website. All right. The Lawrence County defendants filed a motion to dismiss the First Amendment complaint. In general, they allege that the filing of the First Amendment complaint eliminates Lawrence County's offense because they're longer, quote, named, end quote. Yeah, it is kind of important to name the defendants because the being named puts them on notice that they're being sued. And the FAC fails to make any claims against them. Yeah. Additionally, defendants argued that a social security number is not protected by any right to privacy. After being granted, he filed opposition. In general, plaintiff argued that there were sufficient facts pled, and at that stage, the facts must be weighed in the light. In general, the court ruled that because plaintiff repeatedly failed to address the county defendant's assertion that their omission from the amended complaint functions as a voluntary dismissal of the claims against them. Not required to deny defendants' assertions. It is required, though, that you actually assert a cause of action against them. So that's kind of weird. It's kind of weird. This court asserted the plaintiff repeatedly failed to address defendant the county defendant's assertion that their omission from the amended complaint functions as a voluntary dismissal of the claims against them. This is false and is not supported by the pleading. Well, the question is, were they omitted from the amended complaint? Plaintiff made only one response to the defendant's motion. It was in opposition. This would constitute a single failure. Well, you didn't amend. You didn't ask for a second amended complaint. You didn't address them in your opposition. That's two things. And the reason why this is important is because there's the amended complaint, right? 5 days later, there is a motion to dismiss for failure to state a claim by Chapman, Doe, and Lawrence County. Okay, that's September 20th. So we had from September 20th there's the order to show cause as to Lawrence County, right? That's two. So there's two. He vacated them. He filed a response. No. Hold on a second. He filed this response on January 13th that didn't address it. That's three. What was the protective order? I don't even remember this one. Oh, this was the discovery motion. So there's three. Well, then why don't you turn the page, Simon? Jesus. So there's three. I counted three, but let's go back to this. But even if it was only one, if you don't name them and you don't, in your opposition, don't say why they should be construed as being named, then, I mean, that's enough, that's enough. As plaintiff argued in his opposition, a motion dismissed under 12b-6 of the Federal Rules of Civil Procedure challenges the complaint's compliance with the pleading requirements of the federal rules. In reviewing a motion brought pursuant to 12b-6, the reviewing court, accepting all well-pleaded facts as true and viewing those facts in light most favorable to the plaintiff to survive motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Let's look at So an amended complaint takes place of the original complaint, so it must include all of the defendants the plaintiff intends to sue and all of the claims that plaintiff personally intends to raise. The amended complaint should clearly list each defendant the plaintiff wishes to sue in the caption. Thus, because the amended complaint controls who the defendants are in the lawsuit, parties voluntarily dropped from a complaint do not remain in the case. So is he gonna actually address any of these issues? I don't know. I guess that remains to be seen. As plaintiff argued in his opposition, a motion to dismiss under 12b6 challenges a accept all well pleading facts. Yep. Here, plaintiff was not required to make any legal argument, let alone deny defendants incorrect legal conclusions. They need to be named as defendants. That's an incorrect legal conclusion. That's a fucking interesting statement to make. For the FAC, plaintiff had learned that naming a government employee in their official capacity also names their employer and did not wish to name them twice. Well, let's take a looky-loo. So are we in the right circuit? Sixth Circuit, that is the correct circuit. So 8 to 10. The first initially, the court notes that Sheriff Zimmerly and Judge Irving had been sued in their official capacities only, while personal capacity suits seek to impose personal liability upon the government official for actions he does under color of law. Individuals sued in their individual capacity stand in the shoes of the entity they represent. So yeah, normally, like if you sue like the Attorney General, you name the Attorney General in his official capacity, then the state is who you're suing. Official capacity suits represent only another way of pleading an action against an entity to which an officer is an agent. A suit against an individual in his official capacity is equivalent of a suit against the government entity. As long as the government entity receives notice and the opportunity to respond, an official capacity suit imposes liability on the entity he represents. Well, again, let's take a look at the first amended complaint. This is the first amended complaint. So Pam Wagner, in her individual and official capacities, I think she was City of Ironton, right? So City of Ironton, sure, right? Spoljaric and the City of Ironton, right? Yeah. Blankenship and the City of Ironton, right? McKnight and the City of Ironton, yep. Fouch and the City of Ironton. Well, that's interesting. So none of those have, as of yet, addressed Lawrence County was not named in there. Major Chapman was not named in there. Jane Doe was not named in there. So I don't see where this is going. It's not going well. Here, Lawrence County and other government entities are still named on the FAC because the individual defendants being named in their official capacity. Well, Chili's a lot more prone to filing motions than any attorney I've been up against. Most pro se or pro per litigants that I've been up against have been fairly, I mean, I guess except in family law. In family law, everybody wants to file a motion all the time. But in civil, usually pro se litigants are less likely to file motions and things like that, maybe because they don't know what they can file. I think Chili is he files more motions than attorneys do, in my experience. And he files more motions than pro se litigants do, in my experience. And he just outright lies. Like, for example, he is alleging that Lawrence County is named because the individual defendants are being named in their official capacity. And yet, we just went over it where they're not named in their official capacity. We just went over it. Let's look up Lawrence County. Lawrence. Lawrence County is not identified in there. Let's see what another person's name is. Chapman. Let's look up Chapman. During the booking process, John Chapman, the top-ranking jailer, told Decastro he had to get his social security number, which, yeah, I mean, they're going to identify you, and you don't have a right that I'm aware of to not give your social security number. I mean, I guess you could keep your mouth shut, but then they'll hold you until they identify you, which is what they allege here. Threatened with a felony charge for obstruction if he didn't give his social security. So it's just these two. So he talks about Chapman, but he doesn't actually name him as a defendant. So Chile is outright lying because he did not name anybody. Additionally, if discovery showed other liable entities, plaintiff might have amended the complaint to include additional defendants. I might have amended my complaint to include additional defendants. Well, you might. You didn't. You actually amended your complaint to remove defendants. This is really stupid. Additionally, if discovery showed other, since naming Jane Doe's does not solve for timely Since naming Jane Doe's does not solve for timely filings in relation to a statute of limitations, plaintiff saw no reason to include any. But you'd already named the Jane Doe. You'd already named the Jane Doe in your initial complaint. You had named the Jane Doe and identified her. So he purposefully removed this and this. See, this is the Jane Doe specifically that you identified. So you identified the Jane Doe, and then you went back and amended your complaint and removed it. So that's weird and wrong and stupid. Like, this is obviously a loser. I don't even know why he's wasting the court's time with this. Plaintiff's FAC include enough facts to establish liability against government employers, including Lawrence County. It did not. It really did not. Before a motion is granted and before plaintiff is required to oppose any argument, that motion must include a statement establishing grounds for the relief requested. What the fuck is he trying to say there? And he's doing 7B1B. B1B. Must state with particularity the grounds for seeking the order, yeah? But why? So Chile didn't address the defendant's assertions that they were not named and therefore he had dismissed them. He could have simply moved to file an amended complaint, a second amended complaint, to correct his own clerical error of removing the allegations against Lawrence County, against Chapman, and against Jane Doe. He did not. So he's not required to deny them, but he should address them because he really needs to. B, Social Security number privacy. Whether a Social Security number is protected by a right to privacy, defendants do not allege had any right or need for that information. A jailer threatening someone's liberty for 6 months if the citizen didn't do something unnecessary and which the jailer had no authority to command is a clear abuse of power. Citation needed. And why? What grounds does Chile have to say that the citizen didn't do something unnecessary? A jailer threatening someone's liberty if they've been arrested and are refusing to supply information sufficient to identify themselves, maybe that isn't a clear abuse of power. Lower pleading standards. To state a civil rights claim under 42 U.S.C. 1983, a plaintiff must set forth facts that, when construed favorably, establish the deprivation of a right caused by a person acting under color of state law. Okay. Plaintiff is only required to plead the facts, not make legal conclusions. Yes, but he pled facts about the jailer. As far as Lawrence County is concerned, those are the only facts he pled about Lawrence County. He did plead and include video evidence of him entering a traditional public forum to exercise his First Amendment rights, and that he was denied a permit and arrested as a result, and that this is a policy, blah, blah, blah. But this would be useful against his against any allegation that he had failed to, well, again, a lot of these aren't facts. But this would be at least an argument addressing any arguments made by the city of Ironton and the city of Ironton defendants that he hadn't pled facts about them. But a traditionally public forum, that is a legal conclusion. To exercise his First Amendment rights is a legal conclusion. Denied a permit is a fact. Arrested as a result, he could allege that as a fact, that he was arrested as a result of being denied a permit. I don't think he was arrested as a result of being denied a permit. I think he was arrested as a result of being in the city hall after it closed. But none of this has fuck all to do with Lawrence County. Plaintiff further alleges, based on information and belief. See, why are you alleging things now? And what does your arrest have to do with the county? What does this have to do with the county? None of this has shit to do with the county. Even where a pro se plaintiff leaves out facts, his complaint must only be dismissed where, if allowed, he could prove no set of facts which would entitle him to relief. Is that what these say? No set of facts? 46. At 46. Well, that's interesting. That's a 1957 case. I think normally it's the case where if you don't plead the facts, then it will be dismissed and you'll be given an opportunity to replead. So they say that the complaint adequately set forth a claim upon which relief can be granted. So in this case, in Connolly, the court found that they adequately set forth a claim upon relief can be granted. So, that doesn't say what he wanted it to say. And then this one is another old case. Let's see what it says. 520. He should probably cite the cases that are post Twickball, but whatever, doesn't really matter. Besides the claims raised, plaintiff has likely also stated facts sufficient for claims of fabrication of evidence, supervised liability, failure to intervene, conspiracy, and abuse of power by a jailer, among others. Has likely? Maybe. That's a weird way to phrase it. Here, defendants ostensibly arrested plaintiff for violating Ohio's criminal trespass law, but that was in the county. Those were the city defendants. Here, the court made an error when applying pleading standards to the fact. Leave to amend. When a motion to dismiss a complaint is granted, courts typically permit the losing party leave to amend. Plaintiff requested leave to amend prior to dismissal. A district court should normally grant a pro se plaintiff leave to amend. I think the court will grant a leave to amend. Normally, you have to attach your amended pleading. A helicopter. So I'm surprised. Let's see if there's anything in the local rules. Here. So he really should affirmatively state that such consultation has occurred. He needs to ask for a motion to amend pleadings and see whether or not they'll consent to it. And then provide an order, and he didn't do that. I'm surprised they don't require an amended complaint to be attached to the motion for amended complaint. Excusable error by plaintiff. The court will consider documents filed after the complaint as part of the pleadings. Here, plaintiff has submitted facts in later documents. Again, this is the one where I think the prisoner filed affidavits. That was this one, the unpublished disposition. Citation to unpublished dispositions is disfavored and requires copies of the cited unpublished decisions. Across service of copies. I don't see copies. So this is bad. This is what I like to call bad. So what about this one? So this one is not fucking flies. This one is not, all right? So hold on. Where was it? It was at 220. And there's no page numbers on this. Fucking phenomenal. Oh yeah, page numbers. So again, this is pre-Twickball, so I'm not entirely sure how useful it still is. But that's what he should have cited. He shouldn't have cited a unpublished decision. But he's dumb, and he says dumb things, and he does some things. Here, plaintiff has submitted facts in later documents, but you didn't name fucking defendants in later documents. That's the problem. The problem is you didn't name the county defendants. If you don't name them as defendants, it doesn't matter what facts you allege. You didn't name them as defendants. He lays out all the facts for his claims. The only facts that he alleged is that a jailer demanded his social security number. I still think he'll be allowed to amend his complaint. I could be wrong, but I think he'll be allowed to amend his complaint. Now, his shittiness, his general shitty attitude might affect the court's decision. His excessive motion filing might affect the court's decision. His shitty disposition on the motions for protective order might affect the court's disposition. The fact that the magistrate judge had to basically chide him for being a generally shitty person might affect the court's disposition, but we'll see. All right, so we're going to go through some comments. Yo, hey, happy Sunday. Happy Sunday to you too, Kim Working. Hello, Sergeant Rock. I am the master of mumbling. I am the master of baiting. How about that? Do you think Sean, LIA, has grounds to sue Mark for defamation? Defamation is a disfavored cause of action, at least as far as I'm concerned. Generally speaking, even if you can prove defamation, per se defamation, that just means you're entitled to $1. It's hard to prove loss, pecuniary loss, monetary loss. And so I don't think so. Generally speaking, I'm going to caution people against lawsuits for defamation simply because the actual monetary loss is probably nil. Somebody says something bad about you. Did it cost you any money? Probably not. I am not a drunken bastard. I only play one on YouTube. Well, you know, I'm not an alcoholic. I'm just a drunk. Good evening from Great Britain. Good evening to you too. I hope you have a lovely pond. Why does Merb wear a belt with no pants on? It keeps the, it's garter belt. It's for my socks. Duh. Some of us like that. Some of us do. What do you have against Japanese tourists? I've already answered. My dick. Come on, roast his ass. Roast whose ass? X equals Y equals smell jock socks. Okay. Hey, you are mostly on time. Welcome, Papa Sanser. Does this look like a effing airport? This does not look like an effing airport. Close enough for government work. Indeed. Don't announce arrivals and departures. We don't give a fuck. Sometimes it's nice to be nice. Have you tried it? Come on, roast that turd. I don't know who you're talking about. I don't remember asking or caring if you did, but please continue. Watch out for those bad chickens. Decastro 2023. There are no bad chickens. There are only bad chicken owners. Need you opinion, Merb. OTVO. Overturn Terry versus Ohio. JBTP. Jackboot Thug Pig. Dick equals Jose. Ask for a friend. Lock up Trump. Okay. That's a double up. Some of those are definitely words. Indeed. Another L in the decastrated column. Thrown out. Is dealy-do a legal term? It is. But no beer goggles is a defense. Is Chili's lawsuit against Kate still active in California? My understanding is yes. I believe the only one I'm aware of, because people don't really keep me up to date, the only one I'm aware of responding is Blue Bacon, who apparently got an attorney to do a fairly shit response. Did I show that? Let's take a small detour. Take a small detour. Can we do a small detour? Decastro versus Peter et al. Let's see. It's that one. I don't want that one. I want this one. It's a pretty low bar number. This guy's probably been around a while. Guy? Girl? I don't know. Let's look him up. Her up? Him up? California State Bar Attorney Search. Attorney search. Let's find us an attorney. State bar number 164057. Oh, you don't see what I'm looking at. 164057. All right. We're going to share this tab and we're going to do that. Ooh. Admitted 1993. Harm. See page 13. Multiple acts of wrongdoing by permitting the Hatsis matter to be dismissed and failing to return to the Hatsis the unearned portion of the advanced fee. That's no bueno. That's no bueno. All right. Where was I? Was it you? There you go. All right. Piratini's answer. So general denial. So the all you're required to do, unless the plaintiff files what's called a verified complaint, i.e., where at the end of it they have a verification that says, I swear under penalty of perjury under the laws of the state of California that the foregoing is true and correct, except for those things that are stated on information and belief. And as to those things, I believe that they're true and correct. And then you sign, date, sign, yada, yada. Unless there is a verification, unless it's a verified complaint, all you have to do is just generally deny it. And so, boop, and you could just do a simple form. California General Denial Judicial Council Forms General Denial. I must have gone through this with you, but here it is. Defendant general denies, and then date, sign. If you are going to do affirmative defenses, see, you have to state the facts. California is a fact pleading state. We're not a notice pleading state, and so you have to actually state the facts that lay the foundation for any affirmative defenses. Oh, you're not seeing it. So you just put the defendant name there, date and sign. So I mean, it could have been fairly simple, but it's a fact pleading state. You have to state the facts. So, but he generated a form, and then he lists out his first affirmative defense, and he names actually 0 facts. He states 0 facts. Yeah. Yep. States 0 facts. So all these affirmative defenses are garbage. Now, that's normal. Just stating the affirmative defenses, just listing them and not citing any facts is normal. There is a judicial council form. Form interrogatories. general. Oops. Disk 001. Show this tab instead. So it's 15. So all you have to do is check that box, identify each denial or special or affirmative defense, and A, state all the facts. B, say all the people who know the facts. C, identify all the documents that have those facts in them. So if Chili does that, if he sends this document, fills out this upper part, and then just serves this document with 15.1 checked, then basically you'll get to learn. Now, what will happen? What will happen is Piratini's attorney will send back answers, and all the answers will basically be like, we're basically reserving this affirmative defense in case discovery shows anything. We're not waiving it, but as of yet, we don't have any facts to support it. Theoretically, you could file a motion to strike at that point. Now, most people don't because it's a waste of fucking time. If they don't have facts to support it, then don't even fucking worry about it, is really the way it works. But, you know, with Chili, who the fuck knows? Chili probably will do all that fun stuff, and good for him. So yes, it is still active as far as I'm aware. I don't get a lot of updates in my server about it, so I can only assume that people aren't that interested in it. If you post stuff into my Discord, that means you're interested in it, and I'm much more likely to cover it. The law scholar doesn't understand what a hearing is in this context. Apparently he doesn't. Apparently he thinks it actually has to be like a oral hearing, but whatever. Oral. Doesn't matter solely, so Chili can say in the future, but that may have happened that way, but only because there wasn't a trial or hearing. Maybe, but there was a hearing, so I don't know why. Hi, Michelle. Michelle, is that Michelle? Michelle? You have a new icon? You got rid of the dog? That's... the train has left the station. No one gives a crap about Chilota, and yet you're here. So I think you do. He bought all the subs. Well, you seem to be talking about him, even in my comment section. So you appear to give a crap about him. Overturned Terry versus Ohio. I don't like the case, so I would not mind it being overturned. Steve Miller talks. The mental image of Chilito asking for oral is disturbing. You'll be hearing from my attorney over the trauma you've caused me, Merb. Well, I believe that Chili is a giver, not a taker. I think he's a power bottom, and I think he would be the one slurping the noodle. Usually for money. I think he does it for money. I think he's gay for pay. But you know what? There's nothing wrong with that. Sex work is real work. Chili, once again, said he doesn't care if he wins. I believe it is bragging rights on his part. Well, he's not going to win, so there you go. Is Mark Stout still practicing his form of law? I don't follow him. Neither do I. Like Chili? Question mark. Oh, nothing. Just a tropical storm here in SoCal. Yeah, it's heading our way. Apparently it'll be here Monday, but it's just supposed to be rain. I'm not terribly worried about it. Burns. What in everything sacred and pure am I looking at? I don't know. But I am not sacred and pure, I assure you. Chili Decastro has ejaculated more legal filings. Nice. Merb, please stand up and show us that new jockstrap. Nope, you got to pay for play. And I'm not wearing a jockstrap. Vlad, lol, thanks for the update. And then Hang Loose, I think, or that's Devil Horns. Devil Horns, okay. I thought this was dropped because Chili is a moron. The court granted a motion for summary judgment as to the City of Ironton plaintiffs and a motion to dismiss as to the County of Lawrence. It's not dropped. Hearings are dropped. Cases are dismissed or adjudicated. There's probably attorneys out there that don't have the caseload that Chili does. Yeah, there are a lot of attorneys who have very low caseloads. It's kind of funny. I mean, I have more work than I know what to do with, and there's a lot of attorneys who don't. And I don't know why. Maybe it's just because they only want to take on the cases they want to take on or something. I don't know. They were named in the original complaint, but he took them out of the FIC. I think he even read it out on a live stream. That is true. I'd rather see his trophy, decastrated jewels. I'd rather see his trophy, decastrated jewels on a rope. You're weird. You should seek mental help. My small trophy. You tried to find out what the problem is. Decastro is lawyering. Enough said. That's what makes it funny. He's all mouth around women and old fogies, but the minute a young buck shows up, he bolts. I don't know. There was that tubby fuck who went out with the zip ties and bear spray. That guy was fairly young, but weak. Obviously very weak. We've been looking at the same page for a minute or two. Well, get used to it. Some people read slower than you do. I'm glad you, the missus, the chickens, and the cocks are not underwater. I'm sure the fish would be fine either way, though. Oh, yeah, I'm sure they would be. Speaking of stuff, we actually have another dog now. My sister is moving to Denver, Colorado, and she couldn't keep her dog because he's a pit bull. So a lot of money was spent to transfer a 12-year-old dog from across the country to here. And so now we have a third dog. So fun. An oral argument for Chili is pointless. He'd wind up inviting the judge to perform a sex act on him when the judge decided for the defendants. Possibly. I mean, he didn't ask for one, though, so I don't know why. I've seen him ask for oral arguments before. He didn't ask for one on this case, though, because I'm not wearing pants and I'm in Ireland. Okay. I don't know what we're responding to. My classroom pet is a tarantula. Oh, nice. Someone said he is Ga. Hit a thumb. We had a python in the biology lab when I was in high school named Julius Squeezer. Nice. I've answered that one. Mission 22 is a good cause. It is a good cause. They call me the log. Has a chicken ever gotten inside your house? No. They've gotten into the garage and have gotten into my fish room, but never into the house. He is a waste of resources. Does Chili have a chance at any kind of lawsuit, anything at all? Well, I mean, so whether or not you are likely to prevail in a lawsuit normally comes down to the facts of that particular lawsuit. So I'm sure that there would be situations where he would have a chance to prevail, just in none of the ones that he's currently chasing after. They're just not based on good facts. He needs better facts. Is really his problem. He needs better facts. He has to have some kind of luck, doesn't he? Is everything he filed not standing any chance? Seems the law of average would maybe apply, or am I delusional? Again, it's based on facts. If he doesn't have facts, if he doesn't have good facts to support it, he ends up lying like he's doing in these motions. He's literally been lying about what he said in his filings, like the court isn't going to have a basic understanding of or the wherewithal to go back and look back. Wait a minute, why did I come to this decision? I thought you said X, and now you're saying that you said Y. And so the court's going to go back and look at all these pleadings, and the court's going to understand very quickly that Joey's lying, which isn't going to help him out, and it's going to make it less likely that the court is going to grant him another shot at a second amended complaint. Now, I still think the court will, because he is pro se, and the court generally tends to give people lots and lots of chances, but it won't necessarily. There's a fucking mosquito. 100% losses, that's it. He has a few motions out there that I think he has a good chance on. And I've said it when he does. Just mostly the ones that are actually go towards the merits of the case, the ones that actually are going to be dispositive, he doesn't have a good chance on those. But like on these, a shot at a second amended complaint, fairly good chance. Merb. Why would Nevada let their reaction to Chili's lead to a default? What could be their reason for this? Or do you think this was just an error on their side? I don't know. Honestly, they might be relying just on their immunity, because even if Chili gets a default, the court can't enforce it. The court can't grant the judgment because of immunity. But that said, I would have thought they would have filed a motion to dismiss based on immunity, 12b-6. So I don't know. Like I just don't know. I don't know why they wouldn't do it. And there was another one, Springer. In Springer, they haven't filed anything either. Share this tab instead. So this is Springer. You can see that everybody in Springer, all the defendants in Springer, didn't file any answers. Jason Jones, Mercedes Murphy, the 7th Judicial District Court, Shannon Murdoch-Poff, and Susan Roskell. Now, the 7th District Judicial Court, that does have sovereign immunity. Sovereign immunity only applies to monetary damages, though. You could still get injunctive relief. Anyway, I don't know why they haven't responded on this one either. Now, this might just be my general ignorance. I've never sued a state. I've never sued judges. So it may just be my ignorance in not knowing the procedure on this kind of stuff. We know that the what's her name? The judge, Mercedes Murphy. I think Mercedes Murphy is the one who recused the entire 7th Judicial District Court from a certain case because this Blair Dunn is the attorney on that case, and he has sued them. So maybe it's just my ignorance. I don't know why Defada didn't answer. I don't know why in Springer the 7th Judicial District Court didn't answer. I just don't know. I wish I did. A normal incel masturbates for sexual release. Do you speak from experience? Do you know this? Is this your forte? Masturbating for sexual release? I mean, good on you. Merb, your analysis further convinces me that Shirley is clearly an obvious moron. Oh, good. Merb, didn't know. Is this a double up? It is a double up. Get to the chopper. Shouldn't you be getting ready for foul weather? Get it foul weather because I have chickens. Foul, get it? Purple hearts, black hearts. Clearly, you don't understand scholars. Clearly, too far up California. Learn geography, bro. Yeah, I'm just gonna get a bunch of rain. How many bites at this apple has he had? Isn't he spitting out seeds by now? He's had a lot, but the court might. I still think, if I was a betting man, I'd bet the court will allow him to file a Second Amendment complaint. Merb, are you wearing pants? I'm not. Do you also have an erection, though? Absolutely. I'm also wearing a condom right now. Just, it's better to be safe than sorry. Hey, Merb, how the devil are you this evening as watching from the UK? So pleased I caught this one. How's your cockerel today? Have you ever wanted to eat it? I have 2 cocks, 2 roosters, 3 cocks, technically, 2 roosters. And no, I've never wanted to eat them. These comments suck, you guys, but do they swallow? Did Mission 22 make you give the previous hat back as you misbehaved too much on the previous live? Agreed, by the way. Great charity. No, they did not make me give it back. Apparently they're okay with a little bit of spice. So I gave them the spice. Pink hand waving. Hand pink waving. Hand pink waving. Side face laughing. Hand pink waving. I'm going to hire Rudy Giuliani to sue Chile. I don't think that Rudy Giuliani is taking cases anymore. Do you bring Fabio and/or it's Inigo, not Indigo. Inigo. I-N-I-G-O. Like, hello, my name is Inigo Montoya. You killed my father. Prepare to die. Do I bring them to courthouses? No, I do not. Fabio! This one time in Sovset camp, Julie Annie's been suspended from the practice of law. I don't know who that is. New icon, computer problems. It will come back. Okay. Well, I miss the dog. A blowjob is still a job, right? Abso-fucking-lutely. Is Merb a real law talking guy or a guy that talks law, or is he AI? Yes. T. Rump rebuffed Julianne's request for financial assistance. I don't know what that means. And like, for people who hate Trump, all politicians suck. All politicians hate you. All politicians are doing their best to make the outcomes for you as bad as they can be. I am firmly in the Jimmy Dore camp, where Democrats suck and Republicans suck, and the only difference between them is that is Democrats want to destroy the country, Republicans want to destroy the country, but give you a 2% tax break while they're doing it. That's the only difference. They're both terrible. Biden's terrible. Trump is terrible. Everybody who's running for president is terrible. Like, I mean, there's good people aren't allowed to run for office. They're not allowed to. So, I mean, shit sandwich or giant turd or shit sandwich. Those are your two choices. And you got to eat them either way. Lol Merb's AI. I think street lighting should be motion censored rather than all the time. It has a negative effect on the wildlife. I don't know. I saw on Jimmy Dore today. I don't share a lot of political outlook with Jimmy Dore, but I've come around to a lot of his opinions. And he was talking about green energy, and normally I've been a fan of green energy. Why not? And then he starts talking about how they have wind turbines in the ocean that are killing whales, and then wind turbines on land are killing birds, and then all of these require battery. I mean, it's all bad for the environment. I'm like, oh Jesus. Now I would love it if there was like some, like, I guess that's, I guess we're down to just nuclear, but and then even then you have to store the spent nuclear waste somewhere. But I mean, my God, it seems like everything we do is going to have a negative effect on wildlife. Man cans, Dan Clemente. Yeah, he was a soft bitch. Your sister's dog is in great hands. Well, he's getting along well. He came in. They'd been medicating him quite a bit when he came in, so he was kind of like off. He came in on Thursday, and he's getting into it. Like he's playing with the other dogs. He's doing well. He's a little sausage. He's actually alpha, I think, or at least he's second in command. He's put Patty in his place. Siobhan, I don't know. I don't think he's put her in her place, but he's definitely put Patty in his place. Chinley practices the shotgun style of litigation. If you file as many motions as humanly possible, eventually one of them may be successful. It doesn't work that way. And you're not going to run the city of Ironton or the county of Lawrence out of money for their attorney. You just, better facts. You need better facts. Yep. How come your live streams get similar amount of live viewers as Chili's, who has approximately 50 times more subs? Probably people are here hoping that I stand up. They want to see my dick. Is probably. I mean, I know that's why you're here, Frog. Would a court give you as many chances as they do Chili? Probably not. Whether or not you're supposed to give pro se litigants more leeway, courts generally do. Whether or not you're supposed to, they generally do. Fabio is a loud one. My rooster Oak starts up at 4:15 every day. I can sleep through roosters crowing. They don't bug me at all. They don't bug me one bit. We have what are those called now? They're like chickens. The guinea fowl. We have guinea fowl now. Those I'm not quite used to yet. They're still fairly young, but they make me perk up still. They have a weird call. We've had them before, but they all got eaten because apparently they're really fucking stupid. So we got like 3 or 4 of them, and they all got eaten. I'm thinking of renaming my little silky rooster Chilito. Is it like a bantam? I like bantams. I mean, like, I guess they're not really as useful for egg production, but I think they're cool birds. Even with the default, Chili has to prove his case. They just can't defend it. Yes, a default is different than a default judgment. Frog always brings a receipt. Yes, he does. He is an excellent source of early news. Photal long mop polymorph LARP. Okay. Comes now. Plaintiff Cholita abused by a jailer. Aren't the courts in Ironton aware of his open warrant? The courts in Ironton? Ironton is a city. I don't know. I would assume. But that doesn't mean he can't continue his federal case. I must go. My butler's ready to give me my sponge bath. Sounds lovely. MERB 2024. No, I assure you that the powers that be would not allow me to run for office. And yeah, unfortunately, or fortunately. Welsh News Now. Make sure Blue, he's blue, B-L-E-W, blue. Blue Bear, blue, B-L-E-W. I've never eaten one of my roosters, but I do threaten them with being thrown into a pot quite often. Well, I'm sure that they take your threats very seriously. Anyway, that's it for today. Thanks for watching. Have a great day.